Hello, a very warm welcome to StudyIQ IAS English. My name is Pooja Dwivedi. Today we shall talk about the pick and choose transfer policy that is supposedly being employed by the center to recommend the names and give into effect the names of those judges who are being transferred from one court to the another. The problem is that this pick and choose policy, according to the Supreme Court, is sending the wrong message. We are going to talk about it. From the perspective of this examination, please make sure that you are a subscriber to StudyIQ IAS English. Other than this, please subscribe to my channel to get access to the PDFs that I use here. If you have any queries, you can talk to me on my Instagram and follow me on my threads. So the Supreme Court has flagged the issue of pick and choose by the center in clearing the Collegium's recommendations. What is this basic policy that the government is supposedly following, is allegedly following, is whenever there is a list of names that is being suggested by the Collegium, in one go, the center is failing to transfer or appoint the judges. So this is a pick and choose policy. Shows that there is some kind of opacity or some kind of favoritism that is going on. 11 names of judges recommended by the Collegium for transfer. 5 have been transferred. 6 are still pending. The Supreme Court says that the government is also not very serious about the pending cases that are in the judiciary. Article 222 of the Constitution makes provision for the transfer of a judge from one court to any other high court. The initiation is done by the Chief Justice of India by taking into account the opinion of the Chief Justice of the High Court from which the judge is to be transferred, and also Chief Justice of the High Court to which the transfer is to be effected. Consent of a judge for his first or subsequent transfer would not be required. All the transfers are to be made in public interest. What does that mean? That means effective administration of justice. Simple as that. And the opinion that is to be given by these two Chief Justices, it should be expressed in writing and it should be considered by the CJI and 4 senior most judges of the Supreme Court. What we are talking about here? We are talking about the Collegium, which in itself has been put many allegations upon, such as it is favoring nepotism, favoritism, it is opaque in nature. It also is so opaque that the executive is not able to get into what the judiciary is thinking. But the Supreme Court says that this opacity is needed. Why? To ensure independence of the judiciary from the executive. This is one of the basic structure parts of the basic structure of the Indian Constitution. Once the suggestion has been made by the Collegium, the Union Minister of Law, Justice and Company Affairs would then submit the recommendation along with relevant papers, whatever the opinions are given, whatever the records are to be submitted to the Prime Minister. And then the Prime Minister, on his own understanding, will advise the President as to transfer of the judges who are concerned. After the President has approved the transfer, the Secretary to the Government of India actually in the Department of Justice will inform the Chief Justice of High Courts that are related to it and the Chief Ministers of the concerned state as well. Then the announcement will be officially done in the notification in the Gazette of India. This is the procedure. Alright, so remember Article 222, the memorandum of procedure basically is there. Moving on, now let's talk about the Collegium System. Collegium System is basically a group which is headed by the Chief Justice of India, and other than the CJI, we have 4 senior most members of the senior most judges of the Supreme Court. When it comes to Collegium of High Court, it is the Chief Justice of the High Court and 2 senior most judges. There is a difference. In the original Constitution, there is actually no mention of a Collegium. This has actually evolved with the help of the 3 judges case. I will talk about the 3 judges case as well. However, Article 124 says that Supreme Court judges are appointed by the President of India in consultation with the Chief Justice of India and other judges as he deems fit. That means the judiciary suggests who to appoint and who to transfer. The Collegium consists of CJI and 4 senior most judges of the Supreme Court. I have already told you that. And when it comes to the High Court, according to Article 217, High Court's judges are appointed by the President in consultation with the CJI, Governor of the State and Chief Justice of the High Court. Now, let's talk about the evolution of the Collegium system. I have already told you about Article 124. But every judge of the Supreme Court shall be appointed by the President, and in case of appointment of a judge other than the CJI shall always be consulted. What does this mean? Consultation, what does it mean? Now, to answer this, the first judge's case was there in 1982. Here the Supreme Court held that the consultation doesn't mean concurrence. That means if the CJI says that please appoint this judge or elevate this judge of the High Court as the Chief Justice of this particular High Court, then this is consultation. But if the President doesn't seem eye to eye with the CJI on this matter, then it is not necessary that that person will be appointed as the judge CJI or not, Chief Justice of the High Court or not. So this is something that was actually the primacy of executive. Executive is better than judiciary. This was held by the Supreme Court itself in 1982. But in the second judge's case, court reversed its earlier ruling and held that the advice tendered by the CJI is binding. That means it set the ground for the collegium system. Then in the third judge's case of 1998, SC clarified that the collegium would comprise of a Chief Justice of India and 4 senior most judges in appointments to the SC and 2 senior most colleagues in the case of appointments to the High Court. Moving on, the very infamous 99th Constitutional Amendment, which wanted an NJAC, that is National Judicial Appointments Commission. Here, not only the person from judiciary but executive and the public were also supposed to be a part of this commission to make appointments and transfer of the judges. Now, NJAC has been very contentious between the executive and the judiciary. Why? Because executive wants to have a say in it, but judiciary wants to maintain its independence, which it considers as a part of the basic structure. Then the fourth judge's case of 2015 is actually a culmination of the 99th Constitutional Amendment, where SC struck NJAC down, calling it unconstitutional and maintaining judicial primacy. There are many issues with the collegium system. First is the non-transparency in appointment. That means whatever appointments are being made, on what basis this person is being appointed and why are they being transferred. So there is no set criteria. These many years of service, what kind of judgments they have pronounced, nothing is considered when it comes to a criteria. So we do not know how they are being appointed. That means public welfare is at stake. Nepotism and favoritism, of course, this has been another very rational critique, I must say, because it is supposed to be so opaque that we have to trust whatever the judges are saying. There is lack of diversity because in the Supreme Court, in the High Courts, we are seeing that people from scheduled caste, scheduled tribes, OBCs, women are not being represented properly. There is non-filling of vacancies and difference of opinion whenever it arises. On what basis are they resolving this particular opinion? Issues with certain conventions. So these are the various issues that are related to the particular problem of collegium. Now, as I told you, cases are also pending because of the non-transfer of judges and non-appointment of judges. There is of course going to be an impact on the cases. So cases pending in various courts in the country have crossed the 5 crore mark. This was recently told, and over 5.02 crore cases were pending in various courts, the Supreme Court and the 25 high courts and the subordinate courts as well. So as you see, there is a lack of proper channel where we can understand till this particular time these number of judges will be appointed. On this particular criteria basis, these number of judges will be appointed. So this has to be resolved within the judiciary. If they want to resolve it within the judiciary, they should come out with a plan and discuss it thoroughly within the judiciary only. If they want to safeguard the basic structure of the constitution, at least the public is aware on what basis the judges are appointed. And this also restores the faith in the entire judicial system. That is the need of the hour. I hope you understood this topic well. Thank you so much for watching. Stay updated.